My name is Eric Myers, Government Affairs Director at Minneapolis Area Realtors. We're here early on in this issue, trying to close the knowledge gap with our members on this one. This issue's been up and moving about for about a year or so, but it hasn't always been the clearest communication from the city or from the vendors on this issue. So we're here to bring you up to speed on what this issue is and what NAR's position is on it, and we'll go from there. So I'll talk a little bit about what the TOPA background is, what NAR's position and our action steps are. Then I'll talk more about what's being proposed and a little bit about the status of the issue at the moment, and take questions at the end. Ann was right. As I've been presenting this previously, we had the proponent stuff on the front end, and just with this presentation, we've reordered it. So same content, reordered. What is TOPA? TOPA is the Tenant Opportunity to Purchase Act. It is essentially a first right of refusal, and I think we see terms like first right of refusal. If you were ever involved in commercial real estate, you see it contractually sometimes within a commercial lease. And that's kind of where people may understand the concept from, either from your schooling or if you've ever dealt with a client that's had a commercial lease. Minneapolis is calling a tenant opportunity to purchase, or TOPA. They're actually calling it opportunity to purchase, and they've just reordered the names, the letters and the name here to opportunity to purchase. Understanding that both the term TOPA and opportunity purchase are, on their face, pretty exceedingly positive terms, and actually then the iteration between TOPA and opportunity purchase is even more positive. So I will say that in Berkeley, California, the realtors did fight back against TOPA, and they ended up calling TOPA taking owner's property away. So that might be the reason why Minneapolis has now changed it to opportunity to purchase, because they don't want to have to be saddled with that same nomenclature in terms of the name of this ordinance. But this ordinance was originally passed in Washington, D.C. in 1980. So yes, that makes it about 40 years old at this point. It was amended by the D.C. Association of Realtors in 2017 to exclude single-family homes. And we'll talk more about whether they're thinking about applying it to single-family homes here in Minneapolis or not. It is existent in Washington, D.C., San Francisco, and Berkeley, California is implementing it right now. So really only 3 localities in 40 years. I'll say more about that later, maybe. What does TOPA do? It creates 2 brand new tenant rights. And first is the right of first offer, and second is the right of first refusal. So those are 2 separate rights at 2 specific points in the transaction, pretty far up front. Tenants individually, collectively, or via an assigned developer then exercise their rights as above. Tenants must form an LLC and ultimately create either a condo or a co-op. And so we'll talk about what that looks like then in a little bit. But the realtors' position on this issue is the realtors favor the creation of home ownership opportunities that support a wide variety of housing options. However, we believe opportunity purchase has several drawbacks, unintended consequences, and substantially alters private property rights and property ownership. We'll talk more about that too. Realtors are in favor of housing policies that provide a full range of housing options at prices that Minnesota families can afford. Realtors believe there are more effective ways to create more balanced and equitable marketplace without this ordinance. I will tell you, the realtors I've talked to are not impressed with this ordinance, but they do believe in home ownership, and they do believe in helping their buyers and sellers, and they do believe in the transformational power of home ownership. And most realtors that I talk to, get no greater joy than serving that first-time home buyer. Getting that once tenant into their first home and the transformational power that comes from that. You know, little boys and girls choosing their bedrooms for the first time, you know, moving in, getting a nice new bed and a dresser and a place to call their own. And realtors are really a part of that. So it's kind of where we're at on this issue. Realtors are concerned about this issue because it interferes with the free transfer of real property. The ability of a buyer or of a seller to buy, sell, or let for rent for real property without unreasonable government restriction is fundamental to private property rights. This is a little hard to understand, but let's ask yourself for a second. Do you really own something at all, whether it's real estate or personal property, if you're not allowed to buy, sell, or let it for rent? And so that's why we say it is fundamental to private property rights. I could have a bookshelf in my home, but if I can't sell it or lease it out, or, you know, same things about cars and everything else. So ownership fundamentally comes down to the ability to do what you want without unreasonable government restriction. This ordinance does create and confers by government fiat a tenant right to property where no ownership interest exists. If you go to a car dealer and you lease a car today, you cannot turn around and sell it tomorrow. You don't own it. You can't sell some fractional version either. And that's important because that's kind of what's being discussed here. The other concerns we have about this is this delays market times from 31 days on average right now, 31 to 38 days we're seeing in each different corner of Minneapolis, up to 285 days that a seller would have to wait out this process and either see whether the tenant is going to be able to buy it ultimately, or whether they're able to proceed and sell it to their original third-party intended buyer. This ordinance has assignability and saleability in it, and so that means the tenant could sign their lease on day one, and on day two they have this right of first refusal and right of first offer, and they can sell it. Anywhere the proponents are talking about assignability, they're also talking about saleability, and they can sell it, and they can sell it unbeknownst to the owner. They can sell it for cash, they can sell it for consideration, they can get that money, hold on to it, and they don't even have to tell the owner who they sold it to. So years down the line, if that the owner goes to sell, the owner has to go to the tenant and say, who did you even sell that to? It may not even still be clear at that point, even from the tenant's standpoint, who they sold that off to and how to track that down. It can get very muddy. This does further restrict the supply of affordably priced rental housing by disincentivizing owners from even bringing rental properties to market to begin with. In a city with these kinds of restrictions, some business owners, rental property owners that are looking to go into this business would just potentially choose to do business elsewhere and not bring new rental units to bear in the Minneapolis market. We believe that OTP is completely unnecessary for single-family homes. The current home sale process easily facilitates and is the most effective means for tenant or non-tenant purchase. Tenants in Minnesota are protected in single-family homes, but in other units as well. Tenants are protected by state law. The current lease period must be honored. If a building is sold and a lease is still in place, that lease supersedes the building sale so the sale occurs, but the lease must still be honored. I'm currently in a lease myself. I'm in a 4-bedroom home that I'm renting. My lease is through the end of May 2021. If this building sells today, then my lease is still honored. There may be someone else I have to write my rent check out to, but my lease must be honored under state law. So tenants are already protected. And furthermore, if this place was going to be sold today that I'm potentially in, that I would very likely be the first to know about it. A landlord would come to me and say, by the way, I'm thinking of putting a house on the market. If you're interested, put an offer in. And I'm like, great, I might be interested. Thank you. I very well may just put an offer in. But nothing in this ordinance, there is no financial advantage in what's being proposed comparing TOPA to the current home sales process, because both TOPA and the current home sales process would require me to be credit qualified and have down payment assistance or access, or down payment funds or access to down payment assistance, and both of those things. So if I'm today not credit qualified, or I don't have the down payment saved up, or I don't qualify for local down payment assistance, I'm not getting into this to this home as a purchaser, whether this ordinance exists or not. And then just finally, management companies creating condominiums at the single family level, creating cooperatives at the single family level, bridge financing to get me from here to there, all generally not available or applicable to the single family level. Now, you could say, sure, management companies, yes, some management companies own single family homes, but the rest of those things, incorporating, creating a condominium, you can't create a condominium in a single family unit, and you can't create a cooperative in a single family unit. So, and bridge financing is just not a thing in single family. So it's really, this issue is really a solution looking for the problem in terms of single family homes in particular. When we talk about those two new rights that we talked about, the first right of first offer and the right of first refusal, I would submit to you these new rights aren't created out of thin air. These are reappropriated seller rights. Sellers have the right to sell, currently have the right to sell the property to whoever they'd like, based on a market price from a competitive market of analysis or other analysis that indicates what the price on the market should be, and they'd have that right to sell it. In a TOPA situation where they now have to offer it to the tenant first and wait out extended timelines, those new rights that the tenants are gaining are really the rights of the seller being given to the rights of the tenant. So think of two bundles of sticks, and one, the rights and the sticks are those rights. It would be taking two sticks from the seller and just giving two sticks to the tenant. That's how this works, and that's really what's going on here when they say we want to create two new tenant rights. Really, they just want to take rights from the seller and hand them to the tenant. Obviously, we're going to show you this. We haven't showed you this yet. I said this is reordered, but the market times on OTP are way too long. Tenants are afforded extended timelines, 30 to 45 days to indicate whether they have any interest at all, then up to 120 days for a negotiation period, then another 120 days for a settlement period, and then another 15 days for actual effectuated, executed closing. So we'll walk through this, and you'll see timelines that don't look anything like the current single-family home or multifamily home sale process. OTP and multifamily structures, they would require a majority vote, and the owners, the current tenants that want to become owners, need to create a management entity. So they would need to file an LLC, and then a tenant majority vote is also required to create condominiums or cooperatives, and then they need their accompanying legal documents. So you won't be able to do this by just going to LegalZoom online and printing up your forms and filing it with the Secretary of State's office and calling it good or done for the day. You're going to need some really detailed technical assistance if this were to come to bear, and you were a tenant and you were trying to create your ownership opportunity within your building. Creating cooperatives or condominiums are complicated legal ventures, and you're going to need technical assistance. You're going to need legal assistance if you're going to do this. Unfortunately, when you pass an ordinance like this universally and you apply it to every situation, all the way down to single family, or 2 to 4 units, or 5 units, nothing in this law prohibits for someone from acting as their own legal counsel or trying to, cut expenses out of it. So it is possible to go down a route by which you're representing yourself, but you ultimately, as a tenant or as someone else, don't get the best advice and don't create the best experience for everyone. And we did see some of that in DC. There were failures based on that, people that were trying to go it alone and do it themselves. There were also failures for other reasons, and I think we'll cover those as well. OTP and multifamily structures, the extended timeframes do interfere with generally accepted commercial property practices and transfer types. Think about 1031 exchanges and the tight tax timelines you have for turnaround. You have to sell your first property and then purchase your next property within a certain time frame. And these time frames within OTP don't really accommodate that kind of transaction type, because the time frames for OTP are much longer than what you need for a 1031 exchange. Portfolio sales, probate, there's a whole bunch of transfer types that really just don't fit this commercial property practice. And just furthermore, the idea that you could pass an OTP program and apply it to every property, where every property might not be the best, it might not be completely feasible in every building or situation type. I mean, I think about class A, B, C, D property in Minneapolis, and just ask yourself from a tenant perspective, if I was a tenant in a 20-unit building and it happened to be class D property in Minneapolis, do I really have any ownership? Do I have any interest in becoming a 1/20th fractional owner of that building? I'm not sure that I do. And every building built today, if a new apartment is built in Minneapolis today, if they use the right materials, it's automatically type A property, right? But 10 years from now, 20 years from now, 30 years from now, it's almost always automatically B, C, or D property. As time goes by, properties get older, and they're actually on a course for their own functional obsolescence at some point. And type A property today is type B, C, or D property in 20 and 30 years. So I'm just not sure that in every situation, every tenant is even necessarily interested. We do know that nationwide, we have data from the National Association of Realtors, because they do surveys of tenants across the country. 80% of all tenants across the country do believe, they are looking forward to home ownership today, at some point in the future. So today's tenants are tomorrow's future buyers. And again, our realtors believe in that transformational power of home ownership. And most of our realtors are out there every single day contacting tenants and working with them, sometimes for the better of 1 and 2 years, as tenants clean up their credit or position themselves in other ways to be ready to be purchasers. And they're really helping them through that process. Some of our best realtor client scenarios are the scenarios where the realtor was involved way early on, years in advance, and really helps that family move into home ownership. I'm not sure that a fractional ownership of 1/20th share of a class C or D property is what most people have in mind, in that 80% that say that they're interested in home ownership someday. It just doesn't make a lot of sense to me, at least. Properties must be managed for the long term and maintenance repairs. We did have, including potential per unit cost increases. We did have buildings fail in Washington, D.C., and they failed like this. The tenants become the owners of the property at a fractional percentage based on the total number of units. And then 2 or 3 years down the line, the building needs a new roof, or the building needs a new HVAC system. And now the building and the property owners that now exist, that were previously tenants, who had decent per unit costs as tenants and now have decent per unit costs as owners, are seeing a large potential per unit cost increase, because that ownership now and paying for that expense is having to be managed out of the new corporate entity funds, the LLC funds. And if it was just a couple, 3 years in, they haven't had enough years to have that money and put it aside and have it be ready for these potential large repairs. And so we saw 2 or 3 buildings in Washington, D.C. fail for just that reason, because then the owners have to make that roof repair. The owners have to who used to be tenants, have to make that HVAC repair, and they have to expose everybody to those costs and share those costs over all the units in the building. So we did see some failures in Washington, D.C. on that alone. Again, this program requires technical assistance, help with development agreements, legal agreements, LLC agreements, management agreements, and it just might not be feasible in every situation. Unfortunately, when you pass that as an ordinance, you're potentially applying it to every situation. Hold on one second. So the Minneapolis area realtors did access the NAR Land Use Initiative. We created our talking points. We've contacted the DC Association of Realtors and have been in consultation with them on this issue. We've consulted with the Minnesota Association of Realtors on this issue. Our key industry partners are the builders, both the state level and local, and the Minnesota Multi-Housing Association. We've accessed NAR's Issues Mobilization Campaign Service Department, and we are building a full-scale campaign to mobilize homeowners and constituents across all 13 wards in the city. I'll talk more about that when I talk about where the city is on that on this issue, but we are building a campaign to turn up the volume on this issue and to make sure council members hear from homeowner constituents that may be against this ordinance. What can realtors do? Realtors, you can familiarize yourself with the OTP proposal, familiarize yourself with MAR prepared talking points on this topic, educate agents in your office and your sphere, encourage realtors and agents to learn more, discuss this issue with your clients where appropriate. If you happen to be representing landlords or owner of a multi-tenant building, go ahead and have these early discussions with them. Let them know what's coming down the pike. And it doesn't hurt to tell them what's going on. Be ready to respond for future calls for actions. Connect with the MAR Government Affairs Committee. Connect with me, MAR's Government Affairs Director. Get engaged and take action. So the Minneapolis efforts on this issue to date, I'm just going to walk you through kind of how we got here, because now you might be thinking to yourself, how did we get here? And really, in March 2019, the Minneapolis City Council passed a resolution. It's not an ordinance. It doesn't have the effect of law, but it was just a statement, a value statement from the council to the general public. And they call it the Renters First Housing Policy. And the Renters First Housing Policy just prioritizes, they'll say right here, it prioritizes the dignity, stability, and health and safety of renters in the regulatory and enforcement decision-making. It does this by directing city departments, particularly regular services, to view their work through a renter-centric lens in order to minimize the impact of their actions on the renter housing. And that's great. And also, in particular, they're talking about here is centering on the tenant. And that's great. So tenants first. And so the city council is saying too that every housing issue that they look at, they're going to center on the tenant first. Clearly on an ordinance like this, they've centered on the tenant first. I would submit to you to a certain extent that centering on the tenant is great, but a full analysis of any particular housing policy should really consider all sides, the tenant and the landlord side. The truth of the matter is, the hard truth, and this doesn't necessarily feel good to say, or maybe not always ring true for everybody, but tenant opportunities in housing exist because of landlords. And so you can't have tenant opportunities without landlords. And so just centering on tenants all the time, and I understand what they're doing here. They're trying to reorder 50 or 60 years of what they see as tenants having been at the back of the line. And I totally understand that. And it makes perfect sense to me that you would start to look at some housing policies from the tenant perspective. What I think is missing here is that they're very often, in a number of issues that we've dealt with the city council on already, is they're not only looking at it from the tenant's perspective first, they're looking at it only from the tenant perspective. And we would kind of suggest to the city council a more holistic view that tenants do need landlords, and kind of not the other way around. That's the hard truth. Hard truth is tenant opportunities don't exist without landlords. And so it really is a symbiotic relationship. And I know landlords get painted with the worst brush all the time, but the reality is there's so many good landlords out there that are doing all the best things they can, especially during this time. You know, eviction moratoriums can't kick people out of their homes, but you have landlords reaching out to tenants, tenants reaching back out to landlords, and you actually have two sides of this transaction, working very closely with each other during these times to keep people in housing. Yes, the eviction moratorium statewide in Minnesota says you can't displace that person. Technically, they still owe every month of back rent that they owe. At the end of this, there's a lot of concern about what's going to happen to those individuals when 6 months of rent becomes due and the eviction moratorium is lifted. There are groups out there calling for not just continuing the eviction moratorium, but just canceling rent outright, so that rent wasn't due, no back rent is due, and no one would ever fell behind. Those are great ideas. They're great talking points, but a better idea is the NAR position, which is rental assistance. Let's get dollars into the hands of the tenants, and then have those tenants pay their landlord, catch them up, and keep them in good standing in that building, and keep them in that building. Rental assistance that goes directly to the tenant, or rental assistance in the case of a non-compliant tenant, where the landlord could also apply and say, listen, I've got this tenant here, I've contacted them a dozen times, they seem to be stonewalling me and not responding to me. I'd still like to have get some assistance on their behalf, and the funds can be directed to me, but then this person will be considered caught up. That's kind of a two-part approach to a rental assistance program. That's the NAR position, and just understand that all of that context plays into this issue. There was a lot said there, and I apologize. In September 20th, 2019, the city of Minneapolis held a council study session on TOPA, and they flew these individuals in from Washington, D.C. to talk about the TOPA program in a meeting on the third floor of the Minneapolis City Council in a meeting room. So Danelle Peltier, Terrence Laney from CNHED, the Housing and Community Development arm in Washington, D.C., Michael Diamond, a professor of law at Georgetown University Law Center, and Dominic Molden, a resource organizer for One DC, a tenant organization and nonprofit that helps people convert into TOPA properties. They came out, presented to the Minneapolis City Council their ordinance and how it's been working over the past 40 years, and really laid out a very positive view of TOPA. Very honest, I did attend myself with a number of members. Very honestly, they laid out a very positive and rosy view of the program. They didn't take questions from the group or from the crowd that was gathered, and there were people from all sides in the room. They didn't take questions. It wasn't an open discussion. It was just a study session and a learning opportunity. But they really created a real positive and rosy picture of it, but but they didn't answer some of the more difficult, pressing questions. They glossed over many areas that were, well, what about this challenge? What about that challenge? And they were really not very interested in answering those questions. But they had this study session in September 20th, 2019. So then in first quarter of 2020, the city of Minneapolis issued a request for proposal, an RFP, to seek a vendor that would provide them policy guidance on TOPA. So they put out the RFP. Twin Cities LISC and CNHED, this group out of Washington, D.C., that is the local economic development authority, were both. So Twin Cities LISC was the main vendor that Minneapolis chose, and then they were kind of advised by CNHED, the DC group. So Twin Cities LISC engaged with DC groups, engaged with Minneapolis groups, collected information and data from CoStar and also from the Realtors. We provided quite a bit of housing data in this process too, as they were studying the issue. Even though they were studying an issue at not quite an arm's length, hiring Twin Cities LISC to bring you policy advice is not quite an arm's length transaction. I'm not going to say much more about that. So this is the process that the city of Minneapolis and their vendor, Twin Cities LISC, went through. They worked with city staff, they worked with stakeholders, they worked with the national examples from DC, San Francisco, and Berkeley. And they went through the policy options, they did some local housing market analysis, and then they came up with recommendations. The city of Minneapolis came up with 3 recommendations And those are affectionately referred to as option 1s, 2, and 3 at this point. Option 1, the tenants have the right, a tenant or a tenant organization may exercise the right. And so in this case, if it's an individual tenant, they would notify and say that they're interested in purchasing the property, and then you have to sell to them first, and then you have to wait out these timelines. If it's a tenant organization where multiple tenants have come together to form an entity, same thing. They have the right of first offer, and then they have a second first right of refusal. In this model, on option 1, you can see here there's a bullet point about halfway down the page. It does not require the preservation or increase in affordability of the property. So once the tenants acquire it, there's no long-term requirement to keep that property affordable. And this means that the tenants actually have the right to the increased equity of that property over time. So if it's a $5 million building today and in 5 years it's worth $10 million, then they will have been the beneficiaries of the increase in the value on the equity of that property because they are the owners. Of course, as divided by their fractional shares, but nevertheless, they would get that equity, which does serve those tenants, and that's good for them. Obviously, that's a really positive situation for them. It does not increase affordability of that property over the long term. So in housing policy overall, there's a recognition that you can't really help a tenant build equity and create permanent affordability. Permanent affordability almost always comes at the expense of individual equity, and individual equity programs almost always come at the expense of affordability. This is why a lot of housing policies are considered to be seen as there's no silver bullets in housing policy because there's always trade-offs, and certainly within option 1 there's a trade-off here. A potentially positive trade-off for tenants, but then a negative trade-off maybe for the larger community and future property owners or tenants that would have been in place in that building. So, and our point is not that this then is completely wrong, just that the city council understand those trade-offs and they're aware of it. We're kind of pointing it out. And because the city council had 4 initial, and we didn't cover it here, but 4 initial priorities, and of their 4 priorities, they had both increasing affordability and increasing equity. But understanding that very often those can't be accommodated in the same program or policy. So this is what the process looks like. The flow chart looks like. The example here is for 50-unit properties. You can just mentally scratch that off in your mind because they also do mean to apply the same flow chart to other property sizes. But you see right up at top in the red box, owner notifies the tenants and the city of an intent to sell. And right at that point, as soon as the owner has an intent to sell, then the tenants have this right of first offer. So then you move down to the left to the green box. Let me see if I can get my pointer going. Nope, it's not giving me that option. But you move down to the green box, and the tenants either form a tenant organization or individually, if it was individual, they have 45 days to submit a statement of interest to the owner. Then after that, they have 120 days to make an offer during the negotiation period, and the owner could accept that offer, and then they have 120 days again, plus 40 days to get a lender letter and secure financing, and then another 15 days to close. So you add up the numbers down this side of it, and you're looking at well over 285 days just to close this deal. And again, the owner has been required now to only work with the tenants first. There are other parts of this flow chart as well. You can see past the negotiation period. So 45 days, 120 days, then down on the right here, owner rejects the offer and enters a third-party contract with that original person that they intended to sell with. And now you see in this green box, a new right of first refusal. So right of first offer in red, right up at the top, right of first refusal. This is a second bite at the apple A second right that's been afforded to the tenants. Again, these tenants have no ownership interest yet, but they've been given 2 new sellers' rights, and so they have the right to match this offer, and then they can either match it within 45 days and then secure that financing and close the deal, or the tenants aren't able to match the offer, and then they could proceed to this third-party sale. That's just one part of this flow chart. You can see the yellow part of this flow chart as well. In this case, everything that proceeds from the yellow is the tenant organization having assigned their rights to a developer. And then the developer takes over the rest of this process and this flow chart on behalf of that tenant organization. Of course, they're still owners, but the developer is kind of involved. But you can see it's still the same timeline, same 120 days here, same 120 days there, and a 15 final close. Of course, there is also this one option, whereas if the tenants or the tenant organization didn't submit a statement of interest in 45 days, then the seller is free to sell to a third party. In DC too, landlords are able to potentially try to buy the rights back from their tenants and get waivers from their tenants, so that they can maintain their ability to proceed down this rightmost path. That does happen, and it's happened for the assignability value or the saleability value, and sometimes it's been $10,000, $20,000, $30,000 per tenant to get tenants to sign over their waivers. And in some cases, we had owners or tenants in DC extorting their owners over how much they would want, and we actually have video on that. We don't we're just not just aware of it. We actually have TV news video on just that happening just that way. In option 2, it works a little bit different. The tenant organization, or a qualified organization may exercise TOPA rights. Again, they plan to apply this all the way down to the single family level, 2 to 4 units and 5+ units. So everything's in on this one. And any person or entity that purchases a property using the opportunity to purchase policy continues to use it as a single family dwelling would be required by the city to abide by just cause eviction, source of income discrimination, and rent stabilization restrictions. I will just point out to you that the city of Minneapolis doesn't currently have a just cause eviction standard. Realtors don't have a problem with a source of income discrimination restriction, but rent stabilization restrictions are currently restricted by state law. They're prohibited in any community across the country unless expressly authorized by a ballot measure. And so if the city of Minneapolis were to put rent control on the ballot and pass it, then they could put these rent stabilization restrictions in place. But this option was presented from the vendor to the city and this was a feature of this option. And we've already expressed to the city that the city doesn't currently have a policy on just cause eviction, and they may not have the right to put rent stabilization restrictions in place. When I pushed on this piece and said they may not be able to put rent stabilization restrictions in place because state law preempts them, their answer was, well, we're not lawyers, we don't know, and that really is not quite the answer. So, and they also said, but rent stabilization restrictions would also be voluntary in this program. But what they really meant by voluntary within this program is mandatory voluntary. So that's a really weird sticky wicket right there. Here's their flow chart for that as well. And you see right again at the top in the red box that the right of first offer exists again. And then you have the tenants with the statement of interest in 45 days. You have an offshoot to the right here, which is by which the tenant organization assigns to a qualified organization. And when you ask yourself, what's a qualified organization, just think nonprofit developers. So don't just get confused by the word qualified organization. This means that the city would create a list of nonprofit developers in the city and say that these people are pre-approved and allowed. These are the only people allowed to be considered qualified organizations. I actually believe that there's an antitrust component to that. The city creating preferred vendor lists, that's a problem. That's not generally done in a lot of other places. It's something to be generally avoided. But in this case, the city would be involved in saying who the qualified organizations are. Same process here if they make an offer on their own. Same process here if an offer is rejected halfway through, then the tenant organization gets that second right of refusal. So it exists in this model as well. And then they potentially proceed through to their own sale, or they potentially don't. And then you have the offshoot to the qualified organization this time. And then whereas in option one, the developer took over, in this case, the qualified organization takes over, and the timelines proceed from there as well. Both of these models are much more complicated and contain seller timelines that are much longer than your current real estate practices. Option 3 is a little bit more of a limited. This program is qualified organizations only, so nonprofits only. It applies mostly to just current NOAA properties or any future qualified NOAA properties. And then it requires the enrollment in the Minneapolis 4D Affordable Housing Incentive Program. The Minneapolis 4D Affordable Housing Incentive Program is actually a program that the Minneapolis area Realtors did support when it passed. And the reason is the Minneapolis 4D Affordable Housing Incentive Program provides not only, it doesn't have just a stick in it, it has carrots and sticks. And one of the incentives in the Minneapolis 4D Affordable Housing Program is that owners are afforded preferential property tax treatment. It's akin to the difference between your house being homesteaded, the difference that you might pay if your house was homesteaded versus non-homesteaded. And so, as you know, in a non-homesteaded property, you pay a little higher property tax. And in a homesteaded property, you pay a marginally lower property tax. In the Minneapolis 4D Affordable Housing Incentive Program, once enrolled, the owner still pays property tax, but they do pay a marginally lower property tax as a reward for having kept their building affordable, mostly voluntary, for many, many years. So this carrot program, Minneapolis 4D Affordable Housing, actually was co-authored by the current chair of Chair Goodman, who we discussed earlier, and we were in favor of that program at the time because it had sticks, but it also had carrots. So this option 3 really takes on mostly just NOAA properties. It doesn't apply to every property citywide. It just involves qualified organizations. Now, the downside of this, just analyzing this from a third-party perspective, is there's no tenant. Just qualified organizations emerge as, and so there is no tenant right in this. There's no tenant. The tenant doesn't ultimately become the owner in this model. Just the qualified organization does. But what's happening is, in this one, is that it's preventing the displacement of tenants, and existing tenant communities get to continue to live there, but not as owners. So this option is a little more palatable from the realtor's perspective because it does serve a public purpose, whereas the other two kind of interfere with private transactions. Here's a little more, this is a more streamlined version of the flow charts we've seen so far, and it applies in this case. It's skinnier in width because it doesn't have any rights to the tenants or the tenant organization. It only has rights to the qualified organizations. And again, qualified organizations mean NPOs, nonprofit organizations. So in the end, only the nonprofit organization emerges as the owner here, not the tenants themselves. There are some exemptions that are proposed in this ordinance. I will tell you, there has not been an ordinance draft proposed to the city council at this point. At this point, the city council has just received this research guidance from a vendor that they paid. Now, they paid $100,000 to a vendor to return research guidance to them, and essentially what came out of it was, we're just going to tell you everything about the DC model. Our research is, and our suggestions here have been everything about the DC model. So there's nothing new here. There's no deeper look, or how do we fix that, or how do we fix that. This was all just pulling the DC model to the front and packaging it in a report and turning it over to the city. So it's a little bit questionable on that kind of practice, but I digress. There are some recommendations that they're making by which an exemption would occur and TOPA would not apply. Single-family homes owned by a real person as their first and sole residential rental property. So if you owned a home and you owned only one other home and you rented it out, they would exempt you. But by the time you own a second one, you're clearly in the business, you're clearly a landlord, and then TOPA would apply. Also excluded in this ordinance is any single-family home where an ADU, there's a lot of words in that sentence, but where an accessory dwelling unit is in place. So they're not going to apply a TOPA to a single-family home or to an accessory dwelling unit if an accessory dwelling unit exists on a single-family parcel, because they're going to consider that ADU and that primary unit are already trying to accomplish some of the city's housing goals. They're also not going to apply TOPA to any place where it's owned by cooperatives already, cooperative corporations already, because one of the options is to turn it into a co-op, and if it's already co-op, then it makes no sense to apply TOPA to it. And it wouldn't apply to properties that are owned and operated for specific uses. And you can see those listed here: hospitals, convents, monasteries, extended care facilities, etc. And then there's some exemptions based on property transfer types, and family and estate trust transfers, where the owner is selling it to within their family to a new individual, maybe junior's taking on the business and he or she wants to give it to and convey it to he or she so they can carry on the family business. That would they're recommending that that's potentially exempted. Now, we don't know any of these things are going to be proposed or exempted because we still don't have an ordinance in front of us, but this is the policy advice that they've received so far from their vendor that they paid. Corporate transfer, and then transfers from one co-tenant to another co-tenant within the operation of the law, and in some transfers of minority title interest, and certain transfers of interest of property participating in any programs with LIHTC, the low-income housing tax credits. So giving that group the option to continue to do the work they need to do in that space, and that's fine. And then with the courts as well, in any government transfers, because clearly the government's not going to hold themselves to the same standards with the ordinance. So in bankruptcy, foreclosure, or tax sale, it wouldn't apply, or by eminent domain or threat of an eminent domain. So if the government was going to come in and take your property with just compensation or not through eminent domain, then TOPA would not apply. So those are the exemptions. At this point, there's a lot of other information on these slides. We'll make these slides available. These slides are already available on MAR's website. You can dig through them. And so there's some kind of annex information here that I'm kind of rolling through. I'm not going to cover all these. I'll just get to questions at this point, Anne. I know we only have a few minutes left.
Yeah, so far we've just had one come in, and it was when you were talking about option number 2, wondering if we can represent tenants in selling the rights.
Whether realtors would be involved, is that what they're saying?
I believe that we means realtors. Yes.
I do think within any of these programs, the answer to that question is, I think within any version of this, there will be a role for realtors. And realtors are always, we represent buyers and sellers all the time. And we're always, in this ordinance, we would be representing buyers or sellers' rights in accordance with the new law if it were put in place. So yeah, I do think there's going to be an important role for realtors to still play. In fact, to a certain extent, maybe a souped up role, because there's many more restrictions and ordinance language to follow and try to advise the consumer on. Now, we do have to be careful as realtors, because we're always told not to practice outside our scope. So you're not going to want to give advice that is technically legal advice. You're not going to want to give advice that's technically tax advice. You're not going to want to give advice that's technically business advice on how to set up a tenant organization, or how to file for an LLC. Those things are really outside the scope of a realtor. So there are going to be, just like there is currently, there are going to be things outside the scope that you won't be able to advise your client on. Now, what the realtor can do is be that transaction quarterback. They can be that, I can't advise you on how to send up an LLC. I can't advise you on what your condo documents should or shouldn't say. But here's who I recommend, or here's a list of people that do provide those services. And so you also have that role where the realtor ends up being the consummate connector. So good question. Other questions?
We had one more come in asking what the probability of this passing is and when.
Yeah, I think the probability of this passing is actually pretty high. And that's actually why we're trying to close the knowledge gap with our realtors. The timeline is that they do need to bring forward a draft, and we anticipate that they're going to bring forth a draft almost immediately in January 2021. And so the earliest that committee meets in 2021 is January 5th. So at the earliest, we may see this ordinance emerge at that committee. And then as it emerges, it can move very quickly. At that point, it could be scheduled for a hearing in that committee. Once it's passed out of that committee, and it would receive its public hearing in that committee as well. Once it's passed out of that committee, it would get sent down to the city council. The city council does not need to conduct another public hearing, and they could pass it a couple meetings thereafter. So they could honestly move as quickly as they want on this.
That was the last question I've seen come in so far today. You can give it another minute if anybody else thinks of something and wants to send it in.
Hang on for a minute or so and see if there's another question.
Sure.
But I'll wrap it up too. I'll let people know, like, honestly, this is very, very different a process. This new program completely changes ownership. It substantially changes the definition of private property rights. It changes the business practice that you're used to. Right now, when you represent a seller on a single family home, if there happens to be a tenant in place, you can reasonably expect that home may sell in, we're seeing Minneapolis market times less than 40 days. I think 38 days was the last monthly days on the market cumulative for city. Now, and throughout the city, in different corners, obviously, those numbers are actually even lower in many places. So you're selling homes, and I know you guys list homes on a Friday and it's sold by Monday, because you get 10 offers in over the weekend. But if there's a tenant in place, you're going to have to wait, instead of 31 days, instead of 38 days, whatever the number is right now, you're going to have to wait more than 285 days. You're going to have to wait 45 days initially just to see if you think your tenant's interested at all. And then if they say that they're interested, and at that point, when they say they're interested, they don't even have to prove that they could potentially consummate the final sale or execute the final sale. They're just saying, yeah, I'm interested. So they get 45 days just to say that they're interested. And then they get another 120 days to continue to negotiate it. So even the first part of this process, where that right of first offer has been implemented, you're already at 165 days before you even know when they're even going to be able to perform on this transaction. So you think about the regular sales process, you think about first-time home buyers, scraping up earnest money and scraping up down payment dollars and doing that quickly versus this process, waiting an extended amount of time, almost up to half a year before you're even just halfway through this process. So this does substantially change the way real estate is done. It's going to slow this market down incredibly. It's going to, over the long term, it's going to lead to a decrease in affordable housing because owners aren't going to bring rentals to bear anymore because they'll just do business elsewhere. They'll just build their apartment complex elsewhere so that they don't have to deal with the draconian rules of the city of Minneapolis. And frankly, it'll just be easier for them to do business in pretty much any other suburb rather than Minneapolis. I'm aware that I've met actually with proponents of this ordinance and the authors, and the proponents are really concerned that REITs, real estate investment trusts, and one in particular, front yard. You can Google it, look it up. It's got a nice, well-maintained home on the front page when you land on it. They're concerned that real estate investment trusts are capitalizing right now and will at some point own 15,000 homes in Minneapolis, and that corporations and outside investors will own homes and people won't. Unfortunately, what I have to tell them is that I represent realtors that represent buyers and sellers all the time, and the vast majority of your transactions, 95% or more of your transactions, are real people, and those buyers are real people. And sometimes the buyers are persons of color, which this group is purporting to help, trying to help with this ordinance. And so I said, so what if you're trying to help a tenant, but the buyer, the otherwise would-be buyer, is a person of color as well? And the proponents turned to me and said, well, you know, Eric, we didn't really understand that. We didn't really think that realtors are out there representing individuals, and individuals are getting home ownership opportunities. And so they turned to us and said, well, we're interested in looking for ways inside this ordinance to keep some of these provisions off of your membership as they help the consumer going public. And I'm like, well, so am I. So hopefully there's a little bit of hope there, and we can keep those dialogues open. I'm at a point in my career where I'm willing to talk to any and all sides at all times, and we just have to see if we can get somewhere on this ordinance. It's very potential. There's a high potential that they could pass this, and that this ordinance could go in place. You know, and so at that, you know, with that, we have to figure out, you know, what the next step is then. And we've covered with, and there are some options available to us if this were to pass, to even still continue to blunt this ordinance. Go ahead with the question.
If it does pass, how long do you think it would take to go into effect?
Well, that's kind of where I was leading to here. I do believe this ordinance in particular would suffer at the hands of a lawsuit. Any place this ordinance has been proposed anywhere, DC, San Francisco, and Berkeley, it's always drawn a lawsuit. And generally, just kind of on average, those lawsuits delay implementation up to 2 years after passage. So if it were to pass in early 2021, it would have an effective date somewhere in the ordinance. And then you would ask yourself, okay, then it would potentially invite a lawsuit. And during the period of a lawsuit, there would also be an injunction, and you wouldn't be able to kind of, the city would or wouldn't be able to effectively put this ordinance in place. So you're looking at potentially a 2-year delay even after passage, because it's very likely to draw a lawsuit. The reason that this ordinance would draw a lawsuit is a couple. One would be from a takings perspective. Those reappropriated seller rights are, it could be argued that's a taking, that's an uncompensated taking from the seller. And that's how likely that, and then there's some other parts of this ordinance too that are highly susceptible. I'm not an attorney, but there are other parts of this ordinance in my experience that are highly susceptible to lawsuits and to being the subjects of the lawsuits. So, and then you also have 2021 as an election year. And so this council is looking to pass as many things as possible to prove to their constituents that they've done things for them. And again, this has a very positive sounding name, and we acknowledge that, and we're aware of it. And so, yeah, I think it behooves the council from their perspective to pass this ordinance as soon as possible in 2021, so that they have more things to go to their consumers or to their constituents with and say that they did for them. I just don't think they're counting on the fact that we represent 10,000 realtors in Minneapolis area realtors. I've talked to a lot of them, not all of them, and I really have not found that many realtors that support this really at all. So it's time for the city council, as they bring this draft forward, to hear from our membership. So any other final questions, or should we leave it there?
Sorry. Yeah, I think we can leave it there. So thank you, Eric.
Awesome. Thank you so much. Have a great day, everyone. Thanks for joining us.
Bye-bye.